sure na naka-off yung mga ano niyo. Okay, so yan. Let's start with our discussion class on the criminal procedure. Then of course, para makaproceed na tayo sa evidence kapag matapos natin early on. Okay, so pag sinabi natin criminal procedure class, of course, mamaya i-explain natin kung ano ibig sabihin nun. Okay, so i-copy ninyo ha. So meron tayong, ang criminal procedure natin class, nagsa-start yan from the Rule 110 to Rule 127. Again, ang criminal procedure natin that is under from Rule 110 to Rule 127. Of course, meron tayong acronym dyan na ginawa ko para hindi niyo makalimutan. Naririnig niyo ba ako? Okay lang ba?
Yes,
Okay lang?
sir.
Okay,
Yes, sir.
sige. Okay, so yung iba hahabol lang yun sila. So again, so ang dapat ninyong malaman under the criminal procedure, of course, meron tayong acronym na ginagamit dyan ng Crime Coach Philippines. So ang acronym natin, class, we have the 3 PABRAM, PRETSUD, NAPS Pro. Ulitin natin. We have the 3 PABRAM, PRETSUD, NAPS Pro. That is the acronym na ginagamit natin under the criminal procedure. So meaning, we have the 3P. Tapos letter A, then we have letter B, we have the R, we have the A, then of course we have the M. We have the PRE, T, JUD, then NAPS Pro. Mamaya isa-isahin natin, class, bihin ng mga acronym na yan. So para hindi nyo makalimutan, kasi class, ganito yan. Sa criminal procedure, in order dapat yan. Okay, in order ha. Hindi ka pwedeng pumunta sa tinatawag natin na appeal kapag hindi ka pa dumaan sa arrest. Kasi nga that is criminal procedure as prescribed under the, of course, under the criminal rules of court natin. Of course, ang pinakauna natin dyan, class, we have the 3P. Okay, unahin muna natin ha. Yung tatlong P, class, of course, yung Rule 110 natin, that is prosecution of offense. Again ha, yung unang P, that is prosecution of offense. Ang second P naman, class, that is prosecution of civil action. Then of course, yung pinaka-last na P, class, that is preliminary investigation. Dito muna tayo, class. Sinabi dito kanina, sinabi ko 3P. So meaning, ang Rule 110, that is prosecution of offense, another P, prosecution of civil action, and another P, that is preliminary investigation or yung alam natin na PI. So mamaya, kapag na-discuss natin every rule, malalaman niyo kung ano ibig sabihin nun. Then we have Rule 113, yan yung tinatawag natin na arrest. Okay? Rule 113, class, yung letter A dyan, that stands for arrest. Then of course, yung Rule 114, that is what we call the bail. Okay? Yung letter B kasi, nagsistart yan. Of course, tawag natin yan bail. Then of course, Rule 115, class, yung letter R dyan, it stands for rights of the accused. Mamaya, malalaman natin kung ano yung rights of the accused, ano rin yung right ng suspect. Then of course, yung letter M, yung Rule 116, yan yung tinatawag natin na arraignment and plea. Again, Rule 116, that is arraignment and plea. And of course, we have the Rule 117, yan yung tinatawag natin na motion to quash. Okay? Motion to quash. Then of course, yung pre dito, class, yung pre na word ito, yung pre. Ibig sabihin yan, that is Rule 118, yan yung tinatawag natin na pre-trial. Then we have the letter T, of course, that is the Rule 119, that is trial. Then of course, Rule 120, that is what we call judgment. Okay, kaya meron tayong Jude dito. Then of course, dito na tayo sa Rule 121. Okay, ano yung tinatawag natin na N? That stands for new trial or reconsideration. Then yung letter A dyan, nakasunod sa N is what we call appeal. Then of course, dito siya, yung may tatlong P dyan, class. Oh, mayroong tatlong P. So ang tatlong P dyan, of course, that is Rule 123. So meaning procedure in MTC, yung Rule 123, yung procedure in CA, yung Rule 124, and procedure 125 naman, yung procedure sa Supreme Court. Yan yung 3P natin. Then we have the Rule 126, yung tinatawag natin na S, that is what we call the search and seizures. Okay, yung Rule 126 natin, class, that is search and seizures. And of course, yung PRO, that is what we call the provisional remedies in cases. Again, yung pro class, that is the provisional remedies in cases. So yan yung tala niyo under the criminal procedure class, that is from Rule 110 to Rule 127. Ang tandaan nyo lang dyan na acronym na ginagamit natin para hindi nyo makalimutan, yung 3 pabram, Pretsyod, NAPS Pro. Again, we have the 3 pabram, Pretsyod, NAPS Pro, Rule 110. Yung tatlong P muna class ha. Yung tatlong P, ang pagkakasunod yan, prosecution of offense, prosecution of civil action, and then yung another P, that is PI or preliminary investigation. Yung letter A, Rule 113, that is arrest. Rule 114, that is bail. Rule 115, that is the rights of the accused. Rule 116, arraignment and plea. Rule 117, yung M, that is motion to quash. Yung 118, yung pre, that is plea trial. Rule 119, that is trial. Yung Jude naman is judgment, yung Rule 120. Yung Rule 121, that is new trial or reconsideration. Yung A, that is appeal. Yung 3P naman class, procedure in MTC, procedure in CA, and procedure in SC. Then we have the what we call the 126. Yung S, that stands for search and seizure. And then yung Rule 127 naman class, that is provisional remedies in cases. So yan yung rule class under the criminal procedure. Nasundan ba ninyo? Nasundan class? Pa-confirm nga kung nasundan ninyo. Okay. So ayan na. So after ng ating discussion mamaya, so dapat na-master nyo yan, yung criminal procedure. So gamitan nyo ng acronym class kasi of course, pagdating sa board exam, okay. So ang mangyayari kasi pagdating sa board exam, yung mga student, tinuruan na sila or nag-lecture na sila, wala silang technique, wala silang strategy kung paano atakihin yan. Kaya ang mangyayari, hindi nila talaga makuha yung tamang sagot dyan. Kasi nga, of course, sa dami ba naman ng binasa nila, sa dami ng na-memorize nila, pero hindi pa rin sila makakasagot kasi nga, wala silang strategy. Okay, yung ginawa natin na 3 pabram, Pretsyod, NAPS Pro, of course, yan yung gamit ng Crime Coach Philippines. Okay? So, ayan. So, I hope na i-master nyo yan after our discussion mamaya. So, para hindi na kayo mahirapan. Okay, let's proceed now sa next natin. Okay, so meron tayong mga common name class of persons in criminal procedure. Okay, pakilagay nga dyan sa ating comment section. Okay, saan ginagamit ngayon class ang term or yung pangalan na suspect? Again, sino yung gumagamit ngayon ng pangalan na suspect? Pakilagay nga sa comment section natin. Sorry. Again, sino si suspect? Under custody. Okay, so si suspect under custody, police parlance. Okay, very good. So tingnan natin yung mga sagutin nyo. How about naman ang respondent? How about respondent? Okay, so how about respondent? Okay, prosecution. Okay, mamaya tingnan natin. How about naman class kapag accused? Okay, so how about naman accused? Court. Okay. Of course, how about yung criminal class? Saan natin ginagamit yung term na criminal? Okay, sige, court. Okay, so let's discuss class kung ano yung tama dito. Of course, class, ang suspect, ginagamit natin yan kapag sa police parlance pa lang. Okay, ang term ng suspect natin, class, that is known today as the persons of interest or the POI. Then of course, number 2 dyan, we have the respondent. Okay, yung mga prosecutor natin. Sa prosecutor's office class, ang tawag natin dyan sa tao na yan is respondent. Kapag accused naman, of course, alam natin, nasa korte yan ang tawag natin yan. And of course, ang criminal class, when the person is convicted by the court of law, ang tawag na natin sa kanya is criminal. Nakuha ninyo? Okay, so I hope it's clear ha. So mamaya ibalikan ninyo ang ating recording at the end of our class. Okay, so court. Okay, very good. So very particular na kayo. Okay, so how about naman class? Sino naman ang gumagamit ngayon ng prosecution party. Okay, sino yung ano yung nare-represent ni prosecution party class? Under the criminal procedure, sino yung pine-present ni prosecution party? Okay, sagutan nyo nga sa comment section, sino yung nare-represent niya? The state. Okay, i-specify yung class, victim ba yan or accused? Offended party. Okay, so yan. Tingnan natin. Okay, may nakita ko mga tamang sagot. Okay, how about naman class, sino naman ang nire-represent ni defense? Okay, sino naman ang nire-represent ni defense? Okay, sino naman ang nare-represent ng defense class? Accused. Okay, so tingnan natin mamaya. Then how about witness class? Okay, yung witness. Okay, so ano ba? Kapag magte-testify ka as witness in court, saan ka magte-testify class? Ano yung dapat? Ano ba? Personal knowledge? Personal perception? Qualified opinion? Okay, ano kapag witness class? Sige nga, tingnan natin sa comment section. Again, okay? So kapag witness class, ano yung tinetestify mo? Ano bang kinukuha sa iyo class? Qualified opinion, personal opinion, and so on. Sige nga. Any idea? Okay, so bakit walang sumasagot? Naghang kayo? Okay. Nandito ba si Kaiza? Testimonial, testimony. How about others? Anong sagot ninyo? Kapag ang witness class, personal knowledge, si Binuya. Testimony. Okay, so how about class, ang state witness? Okay, ang state witness naman, sino yung tinatawag natin na state witness sa ngayon? Okay, sorry. Sino yung mga tinatawag natin or makukonsider natin class as a state witness? Okay? So you are not familiar with the term, so siguro kakarinig nyo lang. So mamaya i-explain natin so walang mag-leave. So para ma-explain niyo sino yung tinatawag natin na state witness? Police? Police ba? Okay, so explain na natin class yung mga terminologies na to. Okay, so pag sinabi nating prosecution party class, of course, nire-represent niya yung tinatawag natin na complainant or yung government or yung tinatawag natin na victim. Okay? So again, ang prosecution party, ang nire-represent niya is the complainant or yung tinatawag natin na victim. Then ang defense party naman class, of course, the adverse party or nire-represent niya naman yung tinatawag natin na accused. Okay? Nire-represent niya naman ang tinatawag na natin na accused. Then of course, ang witness class, di ba, we have the two types of witness. We have the ordinary witness and of course, the expert witness. So mamaya, i-explain ko yung tinatawag natin na two types of witness. Ang HAMI class, ibig sabihin, yan yung tinatawag natin na ordinary witness. Ang CT naman, yan yung sa expert witness. Kapag you are an ordinary witness class, ibig sabihin, magte-testify ka ngayon based on him or HAMI. Okay, kahit kunin na natin class yung yung letter, yung H. Okay, dito na lang. Okay, yung HA, that stands for handwriting. Yung M naman, that is the mental sanity. And of course, yung I, that is identity of the offender or identity of the person. Ulitin ko. We have the two types of witness. So una, we have the ordinary witness. Kapag ordinary witness ka class, magte-testify ka ngayon based on HAMI. Yung HA, that stands for handwriting. Yung M, that stands for mental sanity, kung maayos ba yung pag-iisip ng tao na yan. And of course, yung I naman, that is the identity of the offender. Again, so kapag you are a witness, magte-testify ka ngayon based on HAMI. Ibig sabihin, magte-testify ka based on the handwriting. Yung M naman, magte-testify ka based on the mental sanity. And of course, yung I naman, magte-testify ka naman based on the identity of the person. Matangkad ba yan? Payat ba yan? Okay? So yan yung tinatawag natin na witness. Okay? So yan yung tinatawag natin class na witness. So yan. Okay. So ayan. Then of course, we have the expert witness. Kapag you are an expert witness, of course, magte-testify ka ngayon based on city naman. Okay? Ano naman yung city, sir? Yung S, that it stands for the, yung tinatawag na skills. Yung E naman, that stands for experience. Then of course, yung T, trainings. And of course, yung E naman, education or expertise. Ulitin natin. Kapag you are an expert witness, magte-testify ka ngayon based on CT. Ibig sabihin, magte-testify ka based on your skill, based on your experience, trainings, and expertise or education minsan. So again, ulitin natin, we have the two types of witness. We have the ordinary witness, wherein kapag ordinary ka class, magte-testify ka based on HAMI, handwriting, mental sanity, and the identity of the offender. Ang city naman, magte-testify ka based on skills, based on expertise or education, training, and of course, yung experience mo. Okay, yan yung tinatawag natin na HAMI. Nakuha ba? Naintindihan, class? Clear? Okay, so yan. Sige, thank you. So don't forget to class at maka-off yung microphone niyo para smooth ang discussion natin. Then of course, number 4 class, meron tayong tinatawag na state witness. Sino yung tinatawag natin ngayon na state witness? Ang state witness class, halimbawa, 4 kayo na the suspect or the persons of interest. 4 kayo Then wala talagang pag-asa or wala na talagang paraan yung government or ng state natin or ang korte na makonvict kayong 4. Kasi nga, walang witness na magte-testify. So among sa 4 sa inyong class, magiging state witness kapag you are the least guilty. Again, halimbawa, 4 kayo 4 kayo na suspect. Sa 4 na suspect na yan, wala na talagang pag-asa ang government kung di pumili sa isa sa inyo para makonvict yung other. Okay? Kasi nga, of course, given na sa grupo or gumawa ng krimen, ikaw yung tinatawag natin na least guilty. Ibig sabihin, konti lang yung participation mo or medyo hindi ikaw yung nag-execute. So among the 4, ikaw yung least guilty talaga, class. Kaya, pwede ka ngayon matawag na state witness. Pwede kang kunin ng government or ng state at tawagin or magiging state witness class. Pag sinabi natin state witness class, ibig sabihin nun, ang tantamount ng class or ang epekto nun, you will be acquitted. Okay? It will tantamount to the acquittal. Ibig sabihin, mapapawalang sala ka. Anong mangyayari, sir, ngayon? Sa mga natira, halimbawa, yung 4 kayo, ano yung mangyayari sa 3? Wala ka na pakialam doon. Acquitted sila. Convicted sila. Kasi nga, ikaw, yung tinatawag natin na state witness. Kasi ang kaakibat or ang kumbaga ang weight na pagiging state witness mo, meaning you will be acquitted of a particular crime. So hindi ka na makukulong, hindi ka na rin magbabayad. So tandaan niyo, again, papasok lang ang state witness class kapag wala talagang ebidensya na magpapatunay or magko-convict sa mga kasamahan mo or sa mga tao na yon. So ang choice na or ang choice na lang ng tinatawag natin na korte class ay piliin or pumili sa isa sa inyo, of course provided ang pipiliin nila class yung konti lang yung participation or yung tinatawag natin na the least guilty among the suspects. Ibig sabihin, sa 4, ikaw yung pinaka-least guilty. Ikaw siguro yung konti lang yung participation. Kasi again, kapag maging state witness ka class, swerte ka. Kasi nga, you will be acquitted. While yung kasamahan mo, they will be convicted. Okay? So wala kang magagawa dyan class kapag sinabi ng korte, okay, so magiging state witness ka. Okay? Whether you like it or not, magiging state witness ka. So ayan. Of course, ayaw pa nun, mapapalaya ka or malaya ka or you will be acquitted. But of course, ang kapalit ng class, ang kasamahan mo, of course, magiging convicted sila sa crime. Okay? So yan yung tinatawag natin na state witness. Nakuha ninyo? Nakuha ba?
Sir.
Okay, sige. Ayan, sige. Let's proceed now sa next. So 36 na tayo. So, nandito ba si Kaisa or may klase siguro sila sa Cream Coach Philippines? Okay. Sino naman class ang gumagamit ng term na appealant, appealee, adverse party, and aggrieved party? Okay. Nandito pala si Kaisa. Okay. So, ayan. Sino naman ang gumagamit ng term na appealant, appealee, adverse party, and aggrieved party? Okay. Dito muna tayo, clan, sa appealant. Okay. Sino ang gumagamit ng term na appealant? Sino si appealant class? Sige nga. Kung may idea kayo, kapag may idea kayo class, okay lang magkamali para pagdating mamaya sa explanation. Of course, i-correct natin yan. Again, sino ang gumagamit ng term na appealant? Okay, sa comment section. Okay, so bakit walang sumasagot? Okay, sige. Accused. Okay, how about others? Sino? Convict? Sige, sino pa? How about convict? So, wala akong nakitang tamang sagot Okay, how about naman number 2 class? Appealee. Sino naman si appealee class? Sorry. Again, sino naman si appealee? Respondent. Okay. Respondent ba? O bakit madilim yung aking camera? Okay, baka ayaw niya. What is why? Criminal? Okay, so i-off ko na lang. Okay. Criminal? Okay. How about naman sa tinatawag natin na adverse party class? Sino naman yung tinatawag natin na adverse party? Accused? Again, sino si adverse party? Sino ang nire-represent ni adverse party? Victim. Okay? Okay, how about si aggrieved party naman ka? Sino naman ang aggrieved party under the criminal procedure? Okay, so sino naman si aggrieved party under the criminal procedure? Sino naman sila? Offended party. Okay, so let's answer this one, class. Bakit hindi kaya clear yung aking camera kung pag-open ko ulit? Okay, try ko Oh no, why is that? Okay, so i-off ko na lang camera ko, bakit ayaw niya. Okay, so dito tayo, class. Okay, of course, class, ang appealant, of course, yan yung tinatawag natin, class, as appealing party. Actually, binaliktad ko lang yan para ma-twist kayo. Again ang appealant, of course, yan yung appealing party. Ibig sabihin, sila yung tumatanggap or sila yung tinatawag natin na nag-appeal. Kaya tinawag natin yan na appealing party. Ang appealee naman, of course, that is the adverse party kung saan kontra yung appeal na ginawa ni appealant or yung tinatawag na din na appealing party. Again ang appealant, that is the appealing party, while appealing naman, that is the adverse party. Ang adverse party, of course, tinatawag natin yan na appealee. Ang aggrieved party class, tinatawag natin yan na appealant or yung side ng victim natin. Okay? So yan yung appealant, appealee, adverse party, and aggrieved party. Okay? So nakuha ninyo. So ayan. So of course, class, may explain rin natin yan mamaya. Or of course, as we go on with other rules under the criminal procedure. Okay? So next tayo. Okay, next. Of course, we have what we call amicus curiae. Again, number 1, amicus curiae. Number 2, counsel de officio. Number 3, counsel de parte. And of course, number 5, we have the judge. Okay, again, we have the amicus curiae. Number 2, counsel de officio. Number 3, counsel de parte. And number 4, the judge. Okay, dito muna tayo class sa amicus curiae. Okay, sino yung tinatawag natin na amicus curiae? Okay, ano yung pagkakaintindi niyo ng amicus curiae class? Okay. Friends of court. Okay, very good. So mamaya tingnan natin kung tama yung mga sagot ninyo. I'm sure alam nyo na yan sa akin. Okay, number 2. Yun yung tinatawag natin or sino naman yung tinatawag natin class na counsel de officio. Again, sino naman yung tinatawag natin ngayon na counsel de officio? Again, sino yung tinatawag natin na counsel de officio? Appointed by the court. Pao po ba? Okay, mamaya tingnan natin kung tama yan. Okay, next. Sino naman ang tinatawag natin na counsel de parte? Okay, sino naman yung mga tinatawag natin na counsel de parte class? Sino yon? Again, sino yung tinatawag natin na counsel de parte? Bakit blurred yung camera ko, no? Uh, Okay, so wag na lang ako mag-camera. Sino yung tinatawag natin na counsel de parte? High lawyer, private attorney. Okay, so ayan, very good na mga sagot ninyo class. That's very positive. Private lawyer. Okay? Then of course, we have number 4, judge. Sino naman or anong tawag natin kay judge class in any criminal or any investigative gatherings or proceedings? Okay, sino ngayon si judge class? An officer of the court. Okay, very good. Okay, so ito yung sagot niya class. Pag sinabi natin amicus curiae class, ibig sabihin that is the friends of court. Okay, of course mga lawyer rin yan class na of course the friends of court kung saan kapag kailangan of course mag-a-ask daw ng help ang korte to represent anyone in a criminal proceeding. Kaya it is amicus curiae. Pag sinabi natin amicus, ibig sabihin amigo, di ba? Amigo, ibig sabihin you are friend. Okay? Amigo in Spanish. Okay? Amigos or friends of court. Ang counsel de officio, of course, it is appointed by the court to represent the accused, particularly class yung tinatawag natin na cannot able to represent or cannot afford or not afford to get a lawyer class or counsel. So dyan tayo kukuha sa counsel de officio. It is appointed by the court to represent the accused. Most likely, or particularly mostly class sa Pilipinas, kumukuha yung court or ang nagre-represent kung hindi kaya yung sa PAO or yung sa Public Attorney's Office, tama yung example ninyo, yan yung tinatawag natin na counsel de officio. Okay, it is appointed by the court to represent the accused in a criminal proceeding. So that is counsel de officio. Then we have the counsel de parte class. Of course, it is hired by the accused or yung tinatawag natin na complainant. Or of course, yung victim ng class, a victim can have yung tinatawag natin na counsel de parte. Okay? So counsel de parte. So ibig sabihin, may freedom sila class to choose whether to choose yung ganitong lawyer, kung alam nila kung bibigyan sila ng korte ng galing sa public attorney's office, tapos sa tingin nila medyo matatalo sila, of course, meron silang karapatan to have their own independent and legal counsel class. Ibig sabihin, nasa sa kanila class kung kukuha sila ng lawyer or hindi. Ang importante na naman doon, ma-represent sila in a criminal court. Okay? So yan yung tinatawag natin na tinatawag natin ng counsel de officio. Okay? So yan yung tinatawag. Okay. Then of course, number 4 class, si judge. Okay? Sino ba yung tinatawag natin na judge? Of course, siya yung tinatawag natin na officer in court. Okay? So sino yun? May nag-comment. Okay. So ang PAO class, of course class, always pwede na lang i-represent. Okay? Hindi lang naman hindi lang naman kaya class, hindi lang ibig sabihin accused lang ang i-represent ng PAW. Okay? So ang PAW class, of course, that is yung services nila is free of charge kasi nga they are public or it is they are public officers or employees sila ng government. So anyone that cannot afford a lawyer or a counsel class, pwedeng i-represent ng tinatawag natin na public attorney's office. Okay? Hindi lang class hindi lang PAW or hindi lang yung mga ano yung tawag natin, yung mga accused ang nare-represent ng PAW natin. Nakuha ninyo? So again, anyone, okay, pwedeng i-represent ng PAW class as long as hindi nila kaya, okay? Hindi nila kaya yung ano ito, yung payment, okay? So yan yung tinatawag natin ng Public Attorney's Office. Kaya 'di ba, yung mga walang-walang pera talaga tapos may gusto silang sampahan ng kaso, pumupunta sila ngayon sa Public Attorney's Office or the PAW. Ulitin natin. So, ayan. So, ulitin natin class so para mas maintindihan ninyo lahat. So, ano yung kaibahan ng apat na to? Okay? So, again, pag sinabi natin amicus curiae, again, pag sinabi natin amicus curiae from the word amicus, ibig sabihin amigo, ibig sabihin friends of court. Ibig sabihin, yung mga lawyer na yan class is not involved in the issue or proceeding. But of course, kaya nga friends of court, they can assist yung tinatawag natin proceeding or they can represent any of the both parties. So amicus curiae class, friends of court. Pag sinabi naman natin counsel de officio, from the word itself, counsel de officio, it is appointed by the court class to represent the accused or the party. Halimbawa, yung public attorney's office, they cannot able to pay yung tawag natin na counsel, yung legal counsel, yung independent counsel nila. Of course, ang counsel de officio, it is appointed by the court class to represent the accused or the victim class na hindi kaya yung tinatawag natin na charges kapag kukuha sila ng mga abogado or lawyers to represent them in a court proceeding. Of course, we have the number 3, the counsel de parte. Ang counsel de parte, it is an independent lawyer. It is hired by the accused, it is hired by the complainant, or it is hired by the victim to represent them. Kasi di ba, they have the right under the Constitution to have an independent and legal counsel, preferably with their own choice. Ibig sabihin, karapatan nila yan, kumuha or pumili ng lawyer na of course sa tingin nila, ipapanalo yung kaso nila. Kaya pwede yan class. Ang tawag natin dyan is counsel de parte. Then of course, ang judge class, it is an officer in court wherein he is in charge with siya yung magsisettle ng mga kaso, yung mga actual controversies and cases brought. Okay? Doon sa kanyang tanggapan. Kaya that's why si judge is an officer in court. Of course, he is the first in command in the court system natin. Okay? So again, amicus curiae, friends of court, counsel de officio, it is appointed by the court to represent the accused or any party in a proceeding. Then the counsel de parte, it is hired by the accused, by the complainant, or the victim. Then of course, ang judge natin class, it is an officer in court wherein siya yung mag-administer, siya yung magbigay ng tinatawag natin ngayon na decision on whatever cases na hinahandle niya. So nakuha ninyo? Nakuha class? Okay, so
Yes, sir.
okay, so ayan. So tingnan natin hindi nyo pa makuha. Inulit ko ng 3 times eh. Okay, so let's proceed now class sa tinatawag natin na lecture proper. Okay, sa lecture proper na tayo. Okay, pag sinabi natin criminal procedure class, tinatawag rin natin yan na criminal process. Again, tandaan niyo pag sinabi natin criminal procedure, it is also known as the criminal process. Baka pagdating ng board exam, ang gamitin nila is criminal process. Okay? So again, pag sinabi natin criminal process, that is also known as the criminal procedure. From the title, of course, ng inyong subject, sinabi niyang criminal procedure, meaning it is the methods class. Ibig sabihin, kapag methods, in order yan. Hindi ka pwedeng pumunta sa appeal kapag hindi ka pa dumaan sa arrest. That's why tinawag ng criminal procedure. Dapat in order yan class. Okay, so again, ang criminal procedure, it is the methods or yung tinatawag natin na steps prescribed by the law for the apprehension, ibig sabihin ng apprehension class, pag-aresto or arestuhin yung tao na yon, and prosecution, of course, by filing the complaint or information of any criminal offense. Ulitin natin. Pag sinabi natin criminal procedure, it is the methods prescribed by the law for the apprehension and prosecution of criminal offenses. Yan yung tinatawag natin na criminal procedure class. Okay. Then of course, we have the criminal action. Ano ba yung tinatawag natin ngayon, sir? The criminal action. So, ang criminal action, the state will prosecute. Okay? Paano yung tinatawag natin class na prosecute? Ibig sabihin, magpa-file tayo ngayon ng complaint or information. Then mamaya, of course, malalaman natin ano yung difference between the two. Again, ang criminal action, the state will prosecute any criminal offense or person punishable by law that is from Rule 1, Section 3 of the Rules of Court. So, ayan yung purpose ng tinatawag natin ng criminal action class. Kapag hindi magpa-file ng complaint or information, of course, hindi tatakbo yung tinatawag natin ng kaso. Okay? So, that's why very important yung tinatawag natin ng criminal action. Okay, sino naman ngayon ang magpo-prosecute? Of course, ang public prosecutor lang kasi, except for private crimes. Kasi of course, private crimes, only the offended party can, of course, can file a case. Okay, so mamaya, i-explain natin what is private crime and what is public crimes. Okay, so sino yung magpo-prosecute class? General rule, ang public prosecutor. Pwede naman, sir, pwede ba sir mag-prosecute yung private prosecutors? Of course, pwede naman. But of course, provided na it is under pa rin sa supervision ng public prosecutor. Okay? Public prosecutor. Okay, next. Okay, so meron tayong tinatawag class na jurisdiction versus venue, which is very important in this subject. Okay, pag sinabi natin jurisdiction class, of course, from the word, kapag tanong literal definition ng jurisdiction, pag sinabi natin juris, that means law. Then diction means I speak. So that's why ang literal definition ng jurisdiction, it is I speak of law. Pag sinabi naman natin pag sinabi naman natin jurisdiction, yung meaning niya talaga class, it is the power and authority of the court to hear, try, and decide cases. So that's why yan yung tinatawag natin na jurisdiction. Pag sinabi naman nating venue, it is the geographical division or place where the trial and hearing should take place. Again, ulitin natin. Pag sinabi nating venue, it is the geographical division where the trial and hearing should take place. Okay, so explain natin one by one class. Then magbibigay ako ng example para mas maintindihan ninyo ang jurisdiction versus venue. Okay, so let's explain again. What is the distinction between jurisdiction versus venue? Okay, pag sinabi natin jurisdiction, again class, dalawa yan. Dalawang definition niya. Kapag tinanong, what is the literal definition of jurisdiction? Juris means law and diction means I speak. So that's why it is literally defined as the I speak of law. So yan yung tinatawag natin na jurisdiction. So from the word itself, I speak of law. So ibig sabihin, it is the innate power. Again, pag sinabi natin jurisdiction, it is the innate power and authority. Sino yung authority? Of course, the court. Again, pag sinabi natin jurisdiction, it is the power and authority of the court to hear, try, and decide cases or to settle disputes and actual controversies. Yan yung tinatawag natin na jurisdiction. Halimbawa, in a rape case, okay, sa rape case class, that is punishable by reclusion perpetua to death. Okay, so it is a serious offense. So that's why ang may jurisdiction din class is the regional trial court kasi ang RTC, ang jurisdiction niya is to handle cases or to settle cases which has the penalty of 6 years and up. So that's why ang rape case, papasok yan ngayon sa tinatawag natin na jurisdiction ng RTC. Another example, okay? So in a murder case, of course, papasok yan ngayon sa jurisdiction ng regional trial court kasi yan yung kaniyang jurisdiction eh. Then ano naman yung kaibahan niya, sir, sa venue? Pag sinabi natin venue, tandaan nyo lang yung keyword natin na it is the geographical division, it is the place, it is the situs, or it is the the situs, or it is the place where the trial and hearing should took place. Again, ulitin natin. Pag sinabi natin venue, it is the geographical division, it is the place, it is the situs where the trial and hearing should took place. Okay, halimbawa, nangyari yung murder case sa tinatawag natin ngayon ng General Santos City. Okay, nangyari sa General Santos City. So meaning, saan ngayon sir ang venue ng trial and hearing? Ang pinaka-simple explanation or simple answer dyan, where the trial or where the crime took place, kung saan nangyari yung krimen class, it will determine or it will automatically determine the venue ng trial and hearing. So meaning, ang murder case na nakomit niya, okay, ng offender natin, ang may jurisdiction noon is yung regional trial court. That is, kasi punishable niya ng more than 6 years up. Then of course, sino naman ngayon or saan naman yun ang venue? Of course, sa General Santos City, kung saan nangyari yung krimen. So pwedeng RTC branch, okay? Branch number, blah, 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 and of course, General Santos City. Kung saan nangyari yung krimen class, it will automatically determine kung saan gaganapin ang trial and hearing. Again, pag sinabi natin jurisdiction, it is the power and authority of the court to hear, try, and decide cases and to settle disputes and actual controversies. While ang venue naman, it is the geographical division, it is the place, or it is the situs where the trial and hearing should take place. Again, paano natin ma-determine yung tinatawag natin na venue? Of course, kung saan nag-took place or saan nangyari yung krimen, it will automatically determines the venue of the trial and hearing. But of course, in every rule, there is an exemption kapag nagkataon na yung party or posible makita ng judge na baka hindi maging successful or baka merong suhulan na nangyayari or mangyayari. So that's why yan yung kaibahan ng jurisdiction versus venue. Nakuha ninyo? Nakuha ba, class? Hindi.
Yes, sir.
Okay, so yan. So I hope nakuha ninyo. So paulit-ulit ko na yun, di ba? Yes, okay, very good. Okay, next. So dapat wala na magkamali dyan sa board exam, ha? Okay, next tayo. So let's have the kinds of jurisdiction. Actually, na-explain ko na to. But of course, ulitin pa rin natin. So we have the kinds of jurisdiction class, which is yung acronym or mnemonics na ginagamit natin dyan is GOLEC. Okay, ano yung GOLEC ngayon, sir? Yung G that stands for general, yung O that stands for original, yung A that is affiliate, yung L that is limited, yung E naman that is exclusive, and of course yung letter C that is concurrent jurisdiction. Pag tinawag natin ka sa general, ibig sabihin all disputes, wala siyang pinipili. Okay, lahat ng disputes or lahat ng cases pwede niyang tanggapin. Kaya pwede niyang tawagin natin as general jurisdiction. Ang tandaan niyo lang dyan is yung keyword na all disputes. Pag sinabi naman natin original, ibig sabihin for the first time. Kung saan unang final ang kaso, ibig sabihin siya yung may original jurisdiction. Halimbawa, final ang kaso class sa regional trial court, ibig sabihin siya yung tinatawag natin na original jurisdiction. For the first time, kung saan unang final ang kaso class, doon or siya yung tatawagin natin na original jurisdiction. Pag sinabi naman nating affiliate jurisdiction, ibig sabihin, the case was elevated from the lower court, iakyat niya ngayon sa higher court. Sa MTC, iakyat niya ngayon sa tinatawag natin na RTC. Kapag natalo sa RTC, iakyat niya na sa CA. Kapag natalo sa CA, aakyat na sa Supreme Court. Of course, after the Supreme Court, wala na class. Wala ka nang aakyatan sa langit na kasi yan yung pinakalas mo, yung Supreme Court natin. Then of course, yung letter L, that is limited jurisdiction. Ibig sabihin, only specific cases ang pwede niyang tanggapin dyan. Kasi that yan yung tinatawag natin na specific cases. Halimbawa, ang family court, of course, sa mga minors, and of course, when it comes sa tinatawag natin, of course, designated yan as family courts. So, specific crimes lang yung pwede mong isampa dyan. Then of course, we have the exclusive or yung tinatawag natin na inherent. So, halimbawa, sa Sandigan Bayan Court, inherent na kapag pag-file ka ng kaso under the Sandigan Bayan Court, which is yung tinatawag natin na graft and corruption cases. Ibig sabihin, inherent yan dyan sa Sandigan Bayan or sa SB. Then we have the concurrent jurisdiction. Ang concurrent jurisdiction naman, tandaan nyo, when two courts are handling the same case. Ibig sabihin, ang dalawang korte, pinagsasabay nila or dalawa sila yung nag-handle ngayon ng tinatawag natin na kaso. Kaya tinawag natin yan na concurrent jurisdiction. Ulitin natin. Pag general jurisdiction, ibig sabihin all disputes, ibig sabihin walang pinipili, lahat, pwede mo i-file dyan. Walang original jurisdiction for the first time. Kung sino or kung saan unang final ang kaso class, it will determine yung original jurisdiction. Ang appellate jurisdiction naman, the case was elevated kapag natalo ka sa lower court. Of course, ang option mo is to elevate the case. I-appeal mo yan, class. From the lower court, iakyat yan sa higher court. Ang limited jurisdiction naman, it is a specific cases lang ang pwede nilang tanggapin sa kanilang korte. Then we have the exclusive inherent. Halimbawa, sa Sandigan Bayan Court, inherent yung tinatawag natin na graft and corruption cases. Then of course, ang concurrent naman, when two courts are handling the same case, tatawagin natin ngayon yan as concurrent jurisdiction. Nakuha ninyo? Nakuha ba, class?
Yes, sir.
Okay, so I hope nakuha ninyo. Then of course, we have what we call now as the okay, so paano ba natin, class, ma-acquire ngayon ang jurisdiction? Of course, tandaan nyo lang na acronym dyan is SPP. So una, subject matter or issue. Okay, so halimbawa, yung subject matter or issue, kung ano yung commit na crime. Murder ba yan? Theft ba yan? Okay? Saan ba yan pupunta? Sa RTC, MTC, and so on. So yan yung tinatawag natin na subject matter or issue. Second naman, yan yung tinatawag natin na person. Okay, paano natin makuha, class, ang jurisdiction over the person? Kapag na-aresto natin sila, arrested, kapag nag-voluntary surrender sila, pwede natin makuha ngayon ang jurisdiction over the person. Again, paano natin makuha yung jurisdiction over the person? Of course, by over actual restraint. Yung arestuhin natin sila or hindi na magpaparesto, voluntarily surrendered on the authorities. Kaya yung tinatawag natin ngayon, class, as jurisdiction over the person. Then of course, we have the jurisdiction over the place. Ang jurisdiction over the place naman, class, of course, yun yung place of the commission of the offense. General rule, kung saan nangyari yung prevent, class, it will determine yung jurisdiction. Yung na-explain ko kanina, di ba? So again, general rule, class, ang place of the commission of the offense, it will determine generally, or general rule, it will determine yung tinatawag natin na jurisdiction. Again, paano natin makuha or ma-acquire ang jurisdiction is SPP. Una, subject matter or issue. Second, person, whether person is arrested or voluntarily surrendered. Third naman, we have the place of the commission of the offense. Kasi nga, yung third class, it will determine, or that is the general rule to determine yung jurisdiction natin. Kung saan nangyari ang krimen, or kung saan ang pinangyarihan ng krimen, automatically, it will determine the jurisdiction of the trial and hearing. And of course, ang jurisdiction class. So yan yung ano natin, ang tawag natin na jurisdiction. Nakuha ninyo? Nakuha ba, class?
Yes, coach.
Okay, good. Sige, next tayo, class. Okay, so dito tayo. So, sir, paulit ng subject matter. Okay, ulitin natin ang subject matter. Okay, ang subject matter, class, of course, makuha natin ang jurisdiction over the subject matter or issue. Halimbawa, ang kaso niya na commit na crime is a murder. Of course, kapag subject matter or issue, ang murder papasok yan ngayon sa RTC. So meaning, jurisdiction yan ng RTC. So meaning, ang RTC ang may karapatan na mag-conduct ng trial and hearing over the case na murder. Kasi nga, papasok yan sa jurisdiction niya. Kasi kapag kinuha yan ng MPC class, ibig sabihin, papasok yung tinatawag na lack of jurisdiction. Ang lack of jurisdiction class, it will tantamount to the dismissal of the case. Ibig sabihin, pwedeng ma-dismiss ang kaso kapag wala yung tinatawag natin na lack of jurisdiction. Hindi pwedeng trial and hearing, hindi pwedeng i-hearing yan ni MTC or hindi pwedeng i-hearing yan ni RTC kung wala siyang karapatan, kung wala siyang jurisdiction dyan sa naturang krimen na yan. Okay, so I hope it's the subject matter, person, and place of the commission of the offense. Okay, so ayan. Kapag may question kayo, class, tanongin niyo lang ako. Okay. Okay, welcome. Okay, next tayo. Okay, next we have the, meron tayong question dito, class, din ilagay ninyo ang sagot ninyo sa comment section. So the following are the system of criminal procedure exam. Again, the following are system of criminal procedure exam. Letter A, accusatorial. Letter B, inquisitorial. Letter C, mixed system. And letter D, what if exactly 6 years sa ang jurisdiction? Kapag exactly 6 years, class, jurisdiction yan ngayon ng MTC. Kasi 6 years eh. Kapag exactly 6 years, that is the jurisdiction of MTC, class. MTC. Don't be confused about that. Okay, so ayan, the following are system of criminal procedure except accusatorial, inquisitorial, mixed, or adversarial system. Okay nga? Pakilagay ng sagot ninyo sa comment section, class. Okay, sinabi niya the following are system of criminal procedure exempt. Okay, may letter D. Okay? Okay, so ang sagot natin dyan, class, okay, let's reveal. Okay, ang sagot natin dyan is letter D. Very good, ha? Okay, so meaning, gumagaling na talaga kayo, class. Okay, na-adapt nyo na yung ating technique dyan. So, very good. So, again, the following are system of criminal procedure except adversarial. Kasi, ano si adversarial, class? Anong tawag natin kay adversarial ngayon? Okay, so anong tawag natin kay adversarial? Bakit tama yung sagot ninyo? Sige nga, baka tsumamba lang yung sagot ninyo, ha? So, anong tawag natin kay adversarial? Bakit hindi siya kasali sa system of criminal procedure? Bakit kaya, class? Bakit hindi natin siya tawagin o hindi siya pasok sa tinatawag natin na system of criminal procedure? Sige nga. Wala. Guilty, dispute lang po ang sinusolve nila. Dispute, okay. So ganito, class, ha? Okay, bakit tama yung sagot niyo, mali yung explanation niyo? Okay, pag sinabi, okay, mamaya explain natin. Okay, another question. Okay, a system of criminal procedure wherein you accuse a person and then you file a complaint. Again, it is a system of criminal procedure wherein you accuse a person and then you will file a complaint. Again, it is a system of criminal procedure wherein you accuse a person, then you file the complaint. Okay, mamaya. So, sige, sagot lahat, class, kasi i-explain natin mamaya. Okay. Sige. Okay, so ang sagot natin dyan, that is what we call letter A, accusatorial. Okay, so tama yan, class. That is accusatorial wherein you accuse a person and then you file the complaint. That is accusatorial. Okay, so dito tayo, class. So meron tayong tinatawag na three system of criminal procedure. Tandaan nyo lang. Again, so we have the three system of criminal procedure. Tandaan nyo lang yung acronym na AIM. Again, so we have the AIM. So yung letter A, that stands for accusatorial. Yung I naman, that stands for inquisitorial. Yung number 3 naman, yung M, that is the mixed system. So that's why we have what we call the the AIM plus. Okay, the three system of criminal procedure. So again, una, we have what we call the accusatorial. Ibig sabihin yan, you accuse a person, class, and then you file the complaint, so that is accusatorial. While ang inquisitorial naman, inquiry is secret wherein the violence is used to extract confession. Then of course, ang ginagamit natin, class, in the Philippines is the mixed system. Ang mixed system, it is the combination of accusatorial and inquisitorial wherein magpa-file ka kayo ng complaint, class, and the fiscal will conduct PI or preliminary investigation, class, to determine yung tinatawag natin na probable cause. Again, so we have the three system of criminal procedure. We have accusatorial, inquisitorial, mixed system. Kaya ang explanation, class, bakit hindi kasali si adversarial kanina? Kasi nga, hindi naman siya kasali talaga dito sa system of criminal procedure. Kasi we have the accusatorial, inquisitorial, and the mixed system. Okay. Nakuha ba ninyo? Nakuha ba? Nasundan nyo?
Yes, sir.
Okay. So, yun yung reason, class. Bakit ang sagot natin kanina is adversarial? Kasi sa adversarial, dito yan siya papasok ngayon, class. Okay, mamaya i-explain natin. Okay. Ang adversarial class, of course, yan yung papasok sa tinatawag natin na types of due process. Okay? Yung types of due process naman yun. So mamaya, madaanan natin yun sa class. Okay, next tayo. Or of course, class, yung Supreme Court, okay, ano muna natin, class, ang jurisdiction. Related pa rin na sa jurisdiction. Ang Supreme Court, class, of course, alam nyo yan, merong 15 justices ang Supreme Court, 1 Chief Justice, and 14 Associate Justices. Ang ginagawa ng Supreme Court, class, is the automatic review of the case. Particularly, class, kapag may mga death penalty cases yan dati, automatic review yan ng tinatawag natin na Supreme Court. Again, ang Supreme Court, automatic review of the case, particularly sa mga death penalty natin. Then of course, tinatawag rin natin na highest court kasi nga, of course, wala naman talaga mas mataas pa kay Supreme Court. It is considered as the highest court of the land. Of course, tinatawag rin natin yung class as a review court. Kasi di ba, hindi sila nagkakandak ng trial and hearing. Ang ginagawa lang ng Supreme Court is the automatic review of the cases na nanggaling, of course, sa Court of Appeals. Then, of course, we have the appellate. Appellate rin siya, class, kasi tumatanggap siya ng appeal na nanggaling sa CA. Then, of course, ang Supreme Court, class, tinatawag natin yan the only constitutional court in the Philippines. Meaning, pag sinabi natin the only constitutional court in the Philippines in times of, it is created, class, by the Constitution. The rest, yung CA hanggang sa MTC class, ang nag-create niyan is the special law or the statute. Again, ulitin natin. Pag sinabi natin Supreme Court, class, tinatawag natin yan as the highest court of the land. Okay, tinatawag din natin yan na review, appellate, and the only or the constitutional court in the Philippines. So, that's why tinawag natin yan na highest court in the Philippines. Okay, so yan yung tinatawag natin na Supreme Court. Nakuha? Then, of course, we have the Court of Appeals. Ang Court of Appeals, class, merong 69 justices dyan. Sa tinatawag natin na Court of Appeals, isang presiding judge. Then, of course, meron tayong tinatawag na 68 associate justices. Ang ginagawa or ang trabaho ng Court of Appeals or jurisdiction nila, annulment of judgment of the RTC. Ang decided cases, of course, yung pinagdesisyonan ng RTC class, kukunin yan ngayon ni CA para, of course, i-review. Okay? I-review class. Kaya di ba, i-elevate yung kaso na nanggaling sa RTC papunta kay CA. Then after kay CA, pupunta na yan sa Supreme Court. Then of course, concurrent, yung mga petitions for certiorari, prohibition ng mandamos against the RTC, yan yung mga ini-issue ngayon ni Court of Appeals. But of course, maintindihan nyo yan, class, kapag nag-law school na kayo. Or of course, sa ating sa ibang discussion natin, class, i-insert ko yan. Okay? So, madali lang naman yan. Okay? So, Court of Appeals. Then, of course, we have the Sandigan Bayan. Okay? Ang Sandigan Bayan, that is composed of 9 justices, class, 1 presiding judge, and 8 associate justices. Of course, ang sinisettle nila, class, ang violation of Republic Act 3019, yung Anti-Graft and Corrupt Practices Act. Then of course, we have the RA 1379, yun na unexplained wealth act. Yung bigla na lang yumaman, ng pagpasok niya sa government, wala naman talaga silang ari-arian. Kaya ang tawag natin doon is unexplained wealth act. Okay, unexplained wealth. Saan niya ba kinuha ngayon ang tinatawag natin na kayamanan nila? But of course, class, yung mga provincial heads, mga city heads, kapag yung salary grade nila is 27 and up, jurisdiction niya ng Sandigan Bayan class kapag nakakommit sila ng crime. Okay? But of course, yung patrolman, kapag nakakommit sila ng crime related to their official functions, mag-appeal ngayon sila class sa Sandigan Bayan. Okay? Kasi nga PO1 class, hindi yan jurisdiction ng Sandigan Bayan. Kapag matalo sila class, sa doon, halimbawa natalo sila sa MTC at RTC, mag-appeal sila ngayon sa Sandigan Bayan. But kapag hindi naman na relation yan sa official duties nila or their office, he can appeal to Court of Appeals naman yan. Okay? So yan yung tinatawag natin na Court of Appeals. Okay, Sandigan Bayan, of course, the Anti-Graft and Corrupt Practices Act, and yung tinatawag natin na Unexplained Wealth Act. Okay, Unexplained Wealth Act. Okay, so yan ang Sandigan Bayan. Then of course, we have the RTC. Okay, ang RTC class, of course, ang former name ng RTC, tinatawag natin yan na the Court of First Instance. Again, ang RTC, tinatawag yan natin ngayon as the Court of First Instance. Of course, ang trabaho na or ang jurisdiction ng RTC, yung mga all cases decided by the lower courts in their respective territorial jurisdictions. Halimbawa, yung MTC, of course, mapunta yan ngayon sa RTC. Then of course, exceeding 6 years. Kapag more than 6 years class, kapag nag-exceed 6 years plus 1 day, automatically, jurisdiction niya na yan ng tinatawag natin na RTC. Kaya very important kasi yung pagbigay or paglagay ng +1 in any penalty. Halimbawa, in reclusion perpetua, 20 years plus 1 day to 40 years. So wag na wag yung kalimutan ngayon ang tinatawag natin na +1 day in every penalty kasi nga it will differentiate or it will divide every penalty. So marami nang tanong sa akin, sir, anong purpose ng +1? Ang purpose ng +1 class is to divide every penalty. Kasi kapag walang +1 yan class, hindi natin ma-determine kung ano ibibigay natin na penalty. Perpetua ba, temporal, mayor, correctional, and so on. Again, pag sinabi natin +1 in every penalty, ang purpose ng class is to divide every penalty. So para malaman natin ngayon kung ano yung ibibigay natin na penalty sa mga offender natin. Then of course, we have the MTC. Ang MTC class, of course, yung mga imprisonment of not more than 6 years, papasok yan ngayon sa jurisdiction ng MTC. Okay? Kasi di ba 6 years up, RTC, 6 years below, jurisdiction yan ng MTC. Then of course, yung mga cases, including yung tinatawag natin na criminal negligence, papasok rin yan sa MTC. Yung mga violations class ng, of course, except hindi nila trial and hearing yung RA 3019 and RA 3079 kasi the jurisdiction na yan karos ngayon class ng tinatawag natin na Sandigan Bayan. Okay? Then of course, pasok rin sa MTC class, jurisdiction rin nila yung tinatawag natin na BP 22. Okay? BP 22 o yung tinatawag natin na bouncing check law. Okay? The bouncing check law. Okay? Okay, so before tayo mag-proceed class sa summary procedure, mag-break muna tayo ng 15 minutes, 15 minutes siguro or 20. So para 9 naman tayo mag-end, okay, 9 p.m. or 9:30. So ayan, mag-ano muna kayo class, magkape lang, huwag mo nang kumain, okay? Para mag-break tayo ng 15 to 20 minutes. So babalik tayo wag lang mag-leave, okay? Thank you and God bless. Okay, so let's discuss class or let's move on with our discussion this evening. Okay, so let's proceed now sa tinatawag natin ngayon na summary procedure. So ano ba yung tinatawag natin class na summary procedure? Okay, so ano ba itong tinatawag natin na summary procedure? So pag sinabi natin summary procedure class, it is a procedure in court wherein the court decides the case through the evidence and affidavits class presented by the parties. So of course, we have the two parties in the criminal case. We have the defense party, and of course, we have what we call the prosecution party. So pag sinabi natin defense class, ibig sabihin, of course, yan yung tinatawag natin na sa part accused, di ba? Then of course, ang prosecution party, yan yung part ni victim natin. So ang summary procedure class, walang mangyayari na trial and hearing. Kasi ang judge or jury will determine or will decide the case based on the submitted evidence presented by both parties. Again, kung ano yung binigay ng both parties, yung prosecution and of course the defense party, doon mag-base ngayon ang judge class sa decision niya. No trial and hearing should took place. Yan yung tinatawag natin na summary procedure. Ang purpose class ng summary procedure is to expedite or to achieve expedition of an inexpensive, ibig sabihin mabilis at mas cheaper na determination of cases wherein or without regard to the technical rules. Of course, mabilis sa class but of course pinalo rin yung rules and regulations or yung rules of court. Again, ang purpose ng summary procedure class is to expedite, ibig sabihin bilisan or malesen yung tinatawag natin na of course yung gastos in any criminal proceeding or yung mga court cases proceedings natin. Kasi ang mahal naman talaga. So that's why yan yung purpose ng summary procedure. Ang covered ng tinatawag natin na summary procedure class, ito yung mga covered nito. Number 1, yung mga kapag nakaviolate ka ng traffic rules, regulations, or traffic laws, or any rules under the traffic, so pwede yan papasok ngayon sa tinatawag natin na summary procedure. Natawag rin, of course, or papasok rin sa tinatawag natin na summary procedure, ang tinatawag natin na rental laws. Then aside from that, yung kapag na-violate mo class, yung municipal or city ordinance or city ordinances, of course, papasok rin yan sa tinatawag natin na summary procedure. Then of course, yung mga cases class na merong imprisonment of not more than or not exceeding 6 months, papayasok rin yan ngayon sa summary procedure. Then yung damage to property through criminal negligence, wherein yung imposable penalty does not exceed 10,000 pesos. So papasok yan ngayon sa tinatawag natin the rules on summary procedure. Okay? Yan yung tinatawag natin na rules on summary procedure. Okay, so I hope, so balikan nyo lang class pagdating sa ating recording. Again, ulitin ko, pag sinabi natin summary procedure, the judge or the jury will base his or her verdict or judgment based on the submitted evidence by both parties, the prosecution and defense parties, whether it is an affidavit, whether it is an evidence. So meaning no trial and hearing should take place. Wala na mangyayaring trial and hearing class kasi nga ang purpose niyan is mapadali, ma-expedite, and matulungan rin na ma-resolve ang mga cases na ibig sabihin natin na hindi mahal, okay? Inexpensive. Yan yung purpose ng tinatawag natin ngayon na summary procedure, okay? Then of course, we have the statutory construction of the rules. So again class, statutory construction of the rules, always in favor of the accused. So hindi pwedeng gumawa ng mga batas ang tinatawag natin na ang state natin class without considering yung welfare ng accused natin. Okay? So, di ba? In dubio pro reo. When in doubt, in favor of the accused. Halimbawa, kapag yung parties defense, they failed to provide enough evidence. Ibig sabihin, the evidence by the parties, yung victim and accused, are equally balanced. Kaya papasok yan ngayon sa tinatawag natin na equipoise doctrine or equipoise rule. Tandaan nyo pag sinabi natin equipoise rule, when the evidence presented by both parties are equally balanced class. Sabihin, walang nanalo. So of course, ang mananalo talaga dyan or ang magpapabor or always class under the statutory construction of the rules, it will be in favor of the accused. Okay? So always in favor of the accused yung ating criminal law or our Then of course, we have the two types of due process class. Take note, we have the two types of due process. Kanina, di ba, meron tayong 3 system of criminal procedure, yung AIM, accusatorial, inquisitorial, and the mixed system. Yung adversarial class and procedure of due process, yan naman yung tinatawag natin ngayon na two types of due process. Una dyan, we have the procedural due process. Ang procedural process, class, the person is presumed innocent until proven guilty by the court of law. Again, ulitin ko, ang procedural due process, the person is presumed innocent until proven guilty by the court of law. Kahit sabihin natin tayo mismo ang nakakita na siya yung gumawa ng krimen, but then again, in the eyes of law, he will be presumed innocent until proven guilty by the court of law. So that's why ang tawag natin dyan is procedural due process. Okay? So ang tawag natin dyan is procedural due process. Okay, nakuha ninyo? Okay, then of course, we have the adversarial. Pag sinabi natin adversarial, ibig sabihin, yan yung opposite ngayon, dito na tawag natin na procedural. Ang adversarial class, the person is presumed guilty until proven innocent. Yan yung ginagamit nila class sa ibang bansa. Okay? So, di ba? The person is presumed guilty until proven innocent. Again, we have the two types of due process. Number one, we have the procedural. Ibig sabihin, the person is presumed innocent until proven guilty by the court of law. While ang adversarial naman, of course, the person is presumed guilty before he can proven innocent. Okay? Yan yung two types of due process natin. So, screenshot nyo, class. Okay, sige, tapos na? Okay, so let's proceed now sa next natin discussion, of course. Okay, so tandaan niyo, class, we have the 7 sources of criminal procedure. Again, so we have the 7 sources of criminal procedure. So number 1, that is from Rule 110 to Rule 127, class. That is what we call the revised rules of rules of court. Then of course, the 1987 Constitution. Yan rin yung isang tinatawag natin na sources or the source of criminal procedure. Then of course, third, the various acts passed by legislator. Of course, yung mga lawmaking bodies natin, yung Congress. Then of course, yung civil code, presidential decrees, executive orders, and yung mga court decisions in the Philippines. So yan yung focus ngayon or yung tinatawag natin na sources of criminal procedure. Okay, again, so we have the 7 sources of criminal procedure. Number 1 dyan. So meron tayong tinatawag na rules of court. Always palagi ang rules of court ang pinaka-main source natin. Okay? So yan. Paki-screenshot muna, class, yung 7 sources of criminal procedure. Okay, so wait na. Okay, sige, let's move on. So the next. Okay, so yan, next tayo. So dito tayo ngayon, class, sa criminal procedure na. Of course, ayan, natapos na natin to. Skip na natin kasi na, ayan, again, ulitin natin na. So, i-memorize niyo, class, yung 3 Brown Pretune Naps Pro. So, para mas madali. So, yan, 3 Brown Pretune Naps Pro. Okay, so magsa-start na tayo ngayon, class, ng discussion natin. Okay, so we will start our discussion, class, under the Rule 110 or yung tinatawag natin na prosecution of offenses. Okay, so under the prosecution of offenses, under the Rule 110, pag sinabi natin prosecution, class, of course, it is the process wherein nandyan yung tinatawag natin na inquiry or filing of case in court. Kaya that's why yung word, class, na prosecution, huwag kayong magtaka, pag tinanong sa board exam, ang prosecution na term or word, ibig sabihin yan, it is the inquiry or filing of case in court. Pag sinabi natin complaint, class, of course, na palagi ko itong dinidiscuss. Pag sinabi natin complaint, of course, tandaan nyo lang yung term na sworn written statement. Ibig sabihin, ito yung sinumpaang salaysay. Okay? Na, of course, while ang information naman, it is an accusation in writing. So again, pag sinabi natin complaint, it is yung tinatawag natin na sinumpaang salaysay. It is a sworn. Kaya diba, sworn is nanumpa ka. You take oath. Okay? So that's why ang complaint is a sworn written statement. While ang information naman, class, it is an accusation in writing. So ang common denominator nila o yung pagkakaparehas ng complaint and information, they are used in the to charge a person of an offense or a felony. So yun yung common denominator ng complaint and information. Ang complaint class, of course, it is subscribed or it is signed by OPP, offended party, peace officer, or any public officer. Again, ang complaint, ang nagsusubscribe dyan, tatlo, whether sa tatlo na yan, offended party, peace officer, or any public officer in charge with the enforcement of law violated. Then ang complaint, ang information naman class, iisa lang yung nagsusubscribe dyan. Or isa lang yung tinatawag na nagsasign under the information. Of course, walang iba, si tinatawag natin na prosecutor. Ulitin natin. Ang complaint class, pinafile natin yan ngayon sa prosecutor's office. While the information class, pinafile natin yan sa korte. Ulitin ko, ang complaint that is ang complaint that is a sworn written statement, ang information naman it is an accusation in writing. Both they are used to file or to allege a person convicted or nakakommit siya ng crime under the Philippine law. Pinafile natin ang complaint in the prosecutor's office while the information that is filed before the court. So that's why yun yung kaibahan nila dalawa. Okay, next. Okay, so we have, ang tanong ngayon, who will prosecute criminal actions? Of course, class, ang prosecute land, of course, under the control yan, class, ng tinatawag natin na prosecutor. Specifically, yung public prosecutor natin. But of course, yung mga offenses class na seduction, abduction, acts of lasciviousness, ang magpo-prosecute yan, of course, by filing a complaint, by only the offended party class can file a case. Okay? Yan yung tinatawag natin na private crimes. Tandaan nyo, meron tayong dalawang crimes. We have the private crimes and the public crimes. Ang private crimes, ibig sabihin class, only the offended party can file a case. Ulitin natin. Ang public, while ang public naman, ibig sabihin anyone or any party who is interested in the case can file a case. Ulitin ko, in a public crime, so halimbawa in a crime of rape, consider dyan sa class a public crime. So kapag ayaw ng biktima mag-file ng kaso class, kung gusto ng parents, siya yung mag-file ng kaso ngayon. Kung ayaw ng biktima, ayaw din ng parents, of course, pwedeng ang police officer ang mag-file class ng kaso. Kasi ang rape, it is a public crime. Anyone who is interested in the case can file a case. Any person can file a case. So that's why tinatawag natin yan na public crimes. While ang private crimes naman, of course, ang private crimes, tinatawag natin yan na any or only the offended party can file a case. Ano ba? In the seduction. Sir, pag vowsy po ba, private crimes po ba? Okay, ang vowsy, of course, class, kapag kapag yung nagrabyado class, yung women, of course yung babae talaga yung magpa-file ng kaso. Okay? Kung ang nagrabyado yung child, of course yung child. So, pwedeng i-label natin ang vowsy class as a private crimes. Okay? So, yan. Of course, class, ang vowsy, violations against women and children, that is under the special law, but still, so again kung sino yung offended party, of course siya yung magpa-file ngayon ng kaso. Kasi nga siya yung naagrabyado eh. So again, ang private crimes, only the offended party can file a case. While a public crimes, anyone who is interested in the case can file a case. So yun ang kaiba na ng private crimes sa public crimes. Kaya palagi nating nakikita, bakit kaya hindi natin nakikita class ang pangalan ng biktima in any criminal cases? Or in the complaint or information, nakalagay lang doon, people of the Philippines versus Juan de la Cruz. Ibig sabihin si Juan de la Cruz yung accused. Pero bakit kaya hindi nilalagay ang pangalan ng biktima? Ang nilalagay dyan class is the name or the people of the Philippines. Kasi people of the Philippines, tandaan nyo, that is the real offended party or the ROP. Kasi whatever crimes na nakumit sa ating bansa, it directly affects all. Tayo yan. So that's why kapag may nangyaring patayan or may nangyaring gulo, it directly affects us all. So that's why whoever the accused, okay, of course whoever the victim rather, hindi yan ilalagay ang pangalan niya. Kasi again, kahit iisa lang siya yung victim, lahat tayo actually directly naapektuhan. So that's why ang people of the Philippines, tinatawag natin yan ngayon as the ROP, the real offended party. Kasi again, kung hindi nyo alam, ang nilalagay class yung people of the Philippines kasi nga, of course, lahat tayo apektado kapag may nangyari or may criminalities na nag-took place or may occurred sa isang community or sa isang, of course, ano yung tawag natin sa isang lugar. So that is people of the Philippines. The real offended party. Okay, then of course, class, we have what we call the requisites of a valid complaint or information. Again, kailan natin malalaman na valid or kompleto yung nilalaman ng information or complaint. Of course, tandaan nyo lang yung tinatawag natin na NADICA Planada. Sir, ano kaibahan versus Republic of the Philippines? Okay, yun yung class. Okay, people of the Philippines yun. Or the people of the Republic. Kasi nga, of course, tayo yun. Lahat tayo class naging biktima ng krimen na nagawa ng isang tao. Kasi whether we like it or not, of course, nakaka-apekto yun sa services and programs na binibigay ng government sa atin. So again, meron tayong requisites of a valid complaint or information kung saan matitest natin o malalaman natin ang laman ng complaint or information is valid or yung tinatawag natin na complete. Kompleto nga ba yung laman ng complaint or informations? So halimbawa, meron tayong sinusunod dyan na acronym or mnemonics. Of course, ang mnemonics natin dyan is NADICA Planada. Yung na stands for the name of the accused. Dapat nakalagay diyan, nakaspecify. Designation of the offense. Kung ano yan, ano yung crime na yan, murder, homicide, parricide, and so on. Then of course, we have the cause of the accusation. So yung mga elements, mga qualifying, aggravating circumstances, dapat naka-allege yan. Then we have the place of the commission of the offense, kung saan nangyari yung krimen. So naka-allege rin yan sa complaint or information. The name of the offended party, and of course, the date of the commission of the offense. Again, malalaman natin na valid or kompleto yung requisite or nilalaman ng tinatawag natin na complaint or information kapag ang basis natin is what we call the NADICA Planada. Okay? The name of the accused, the designation of the offense charge, cause of the accusation, place of the commission, name of the offended party, at yung tinatawag natin ngayon, the date of the commission of the offense. Yan yung mga requisites class of a valid complaint or information. Okay? So yan, kompleto yan. Okay, so meron tayong tinatawag class na duplicity of offense rule. So meaning yan class, only one offense should be charged in one information or complaint. Otherwise, quashable yan class. Pag sinabi natin quashable, i-dismiss yan ngayon or ipapastop yung case na yan. Tandaan niyo, bawal yung tinatawag natin na duplicity of offense rule. Yung sa isang information or isang complaint, dalawa yung naka-allege na tinatawag natin na crime na nakomit niya, bawal yan. Unless na lang it is a complex crime, that is the exemption. Pag sinabi natin duplicity of offense rule, ibig sabihin only one offense ang pwede mo i-charge under one complaint or information unless it is a complex crime. Okay? Then of course, exemption class when the laws prescribe a single punishment for various crimes or yung tinatawag ko nga na tinatawag natin na complex crime. Then meron tayong tinatawag class na amendment or substitution. Ibig sabihin, pwede nating mapalitan ang nilalaman ng complaint and information. But of course, merong remedy or merong pagdadaanan yan class. Okay, so a complaint or information class may be amended. Ibig sabihin, pwedeng mabawasan, pwedeng mamagdagan in form or in the substance. Okay, with leave of court. Okay, una, without leave, at isa naman with leave of court. Pag sinabi natin leave of court class, ibig sabihin, you pay or you ask permission from the court. Ibig sabihin, yan yung tinatawag na rin ng leave of court. Without leave of court class, hindi na kailangan magpaalam or hindi na kailangan i-inform ang korte kapag anytime before the accused enter his plea. Yung hindi pa nag-enter or hindi pa naka-enter ng plea, yung accused class, tapos yan yung tinatawag natin, okay, without leave of court. Hindi na kailangan magpaalam na magkakanta kayo ng ganito, ganyan. Okay? Or mag-change yung nilalaman ng complaint or information kasi nga nagkamali kayo. But of course, with leave of court na, kailangan mo talaga magpaalam na, okay, that is the protocol. Okay, kailangan mo na magpaalam with leave of court after the plea and during the trial or the formal amendment only be made. Ibig sabihin, yung format lang ang pwede mo ma-change. Pero when it comes to substance, hindi mo pwedeng i-change yan. Kasi, of course, after na yan, pagkatapos na ng plea and during the trial, only formal amendment can be amended or can be changed. Again, ulitin natin na, ang amendment or substitution, ibig sabihin yan, yung complaint and information class, pwedeng ma-change yan or pwedeng ma-amend yan in a form or in a substance as long as, tandaan niyo, without leave of court, ibig sabihin wala ka ng bayad. Ibig sabihin, or hindi ka na mag-ask ng permission sa court, yan yung tinatawag natin before or anytime before the accused enter his plea. Okay? So, wala pang trial and hearing. Then of course, without leave of court class or with leave of court rather, kapag after na, okay, natapos na lahat, okay, after the plea and during the trial, pero class hanggang formal amendment lang yung pwedeng ma-change. Hindi na pwedeng i-change yung substance niya. Okay? So with leave of court. Then tandaan nyo class ang Solicitor General. Si Solicitor General, he's the one or she is the one may bring or defend actions in behalf of the Republic of the Philippines or represent the people of the Philippines or the state in a criminal proceedings before the Supreme Court and the Court of Appeals. So yan yung trabaho class ni Solicitor General. Kapag ang kalaban or kapag naagabriado ang Pilipinas or ang state natin class, ang magpa-file sa iyo ng kaso class is the Solicitor General. Pero of course, aside from that, not just in Court of Appeals, not just in Supreme Court, pwede rin siya mag-ask or pwede rin siya yung mag-file ng kaso outside. Halimbawa, katulad ng West Philippine Sea, di ba? Sa West Philippine Sea, yung judge natin or yung si Solicitor General ang nag-file ng kaso doon sa ICC or the International Criminal Court or yung mga disputes on the seas. So yan yung trabaho ni Solicitor General. He is the lawyer or he's the counsel of the Republic of the Philippines. Kaya tanawag sa kanya or tawag sa kanya is Solicitor General or Office of the Solicitor General. Okay, so he represent in behalf of the people of the Philippines. Always siya yung magre-represent sa people of the Philippines. Okay, then of course, we have class the prosecution of civil action. Okay, tandaan nyo class, under the Rule 111, prosecution of civil action, when the criminal action is instituted, the civil action is also deemed instituted. Ibig sabihin, when a person is criminally liable class, he is also civilly liable. Of course, there are certain exemptions. Ulitin ko. When a person is criminally liable, he is also civilly liable. Okay, so that's why yan yung general rule under the Rule 111. The prosecution of civil action. When the criminal action is instituted, the civil action is also deemed instituted. Ibig sabihin, kalakip na yan or kakambal niya na yan. Okay, ang exemption of course, number 1, kapag na-waive yan, na-reserve or institute a civil action prior to criminal action. Yung number 3, very important yan, institutes a civil action prior to criminal action. Ibig sabihin, na unahin muna class or nakapag-file siya ngayon ng prejudicial question. Okay? Nakapag-file siya ngayon ng tinatawag natin ng prejudicial question. Tandaan niyo under the Rule 111, acquittal in a criminal case does not bar the filing of civil case. Ibig sabihin, nanalo ka ng criminal case, mananalo ka rin sa civil case. Okay? Pwede ka pa rin sampahan ng civil case. Ibig sabihin, pwede kang sa mga danyos, okay, na incurred mo, pwede ka doong sampahan doon sa ating civil, of course, sa civil cases. Again, general rule, tandaan nyo, when a person is criminally liable, he is also civilly liable. Ibig sabihin, magbabayad siya, makukulong siya. Of course, ang worst class, kapag police officer ang na-involved sa corruption, ang tatlo yan. Okay? Tatlo yung ang titira sa kanya. Okay? Halimbawa, convicted siya sa crime kasi in relation to his duty. Convicted siya sa crime, of course, kapag convicted siya, makukulong siya, magbabayad siya ng mga danyos. Aside from that, okay, anong mangyayari sa kanya? After magbayad ng danyos, pwede rin siya matanggal class sa serbisyo. Okay? Kaya nga, he is criminally liable, he is also civilly liable, and as well as administratively liable. So that is under the Rule 111 or the prosecution of civil action. Yan, class. Okay? So yan yung tinatawag natin na prosecution of civil action. Okay? Please screenshot.
That's
Okay. Okay, class. Sige, let's proceed now sa next slide. Okay. So meron tayong tinatawag, class, na prejudicial question. Pag sinabi natin prejudicial question, actually, pinasa ko na yan sa GC ninyo. Nakita nyo ba kahapon or kagabi? Ang prejudicial question, class. What is prejudicial question? Nakita nyo yon. So dapat huwag nyo i-disregard yung mga pinapasok ko sa GC kasi very important yan. Okay, pag sinabi natin prejudicial question, ibig sabihin, one which arises in a case, the resolution of which is a logical antecedent of the issue involved therein and the cognizance of which pertains to another tribunal. Ibig sabihin, the previously instituted civil action class involves an issue similar or intimately related to the issue raised subsequent to criminal action. Ibig sabihin, whatever the result, class, kung ano man yung magiging resulta ng civil action class, it will determine, magbabase doon, whether or not yung criminal action will proceed. Tandaan niyo, pag sinabi natin prejudicial question, uunahin muna, class, isettle yung civil action class. Di ba? Iaunahin muna isettle yung tinatawag natin na civil action. Okay? Kung ano yung magiging resulta ng civil action class, okay, doon rin magde-determine or doon titignan kung mag-push through pa ba, whether or not the criminal action will push through. Ulitin ko, pag sinabi natin prejudicial question, okay, una dyan, tandaan ninyo, kapag whatever the result of the civil action, it will intimately related or it will affect class kung yung criminal action ba mag-push through pa ba siya. Kasi nga natalo na yung civil action niya, mananalo pa ba siya sa criminal action. Okay, so yung tinatawag natin na prejudicial question. Tapos ang tandaan nyo lang dyan, yung antecedent or the logical antecedent of the issue. Okay? So meaning, kasi uunahin ang civil action, make sure rin na connected rin yung sports or connected rin yung case rather. So yun yung prejudicial question na tinatawag natin. So kailan or when to file the petition for suspension by reason of a prejudicial question? Of course, during preliminary investigation, pwede ka na mag-file ng prejudicial question. Pwede mo kayong class hilingin or pwede mo hilingin, class, sa tinatawag natin na investigador, okay, na magkakaroon or magpa-file kayo ng prejudicial question during PI. Of course, in the court before the prosecution rests its case, so magpa-file ka kayo ng tinatawag natin na prejudicial question. Okay? The letter A, during PI. Letter B, in court before the prosecution rests its case. Okay, so where or saan tayo magpa-file ngayon, class, ng petition for suspension by reason of prejudicial question? Of course, una, class, magpa-file tayo ng prejudicial question at the office of the prosecutor. Second naman, ang korte kung saan yung criminal action has been filed for trial at any time before the prosecution rests its case. Halimbawa, before nag-rest ang case ang prosecution, nasa RTC. So doon ka ngayon mag-file ng petition for suspension by reason of prejudicial question. So ibig sabihin, i-request mo ngayon sa korte, judge, hindi mo pwedeng ituloy yan kasi nga pwede mo ba i-grant yung request ko na prejudicial question? I-trial and hearing muna yung civil case before tayo mag-proceed sa criminal case. Whatever the result of the civil case, it will determine whether or not the criminal case will push through. So yan yung tinatawag natin kung saan magpa-file ngayon ng petition for suspension by reason of prejudicial question. Number 1, Office of the Prosecutor. Number 2, ang korte kung saan yung criminal action naka-file or kung saan at the time yung korte class nag-rest na yung kaso nila or the restless case. Okay, papuntang trial, of course doon ka magpo-file ngayon ng petition for suspension or yung tinatawag natin na prejudicial question. Okay? Okay, so dito tayo kayong class ngayon sa Rule 112. Okay, yan yung tinatawag natin ngayon na PI. Ito yung paborito ninyo, yung tinatawag natin na preliminary investigation. Kaya class, kapag mga ganitong tanungan or ganitong mga explanation, kasi paborito ko to, okay, kahit nakapikit ako, kaya-kaya ko i-explain yan. Okay? So, ang preliminary investigation class, tandaan nyo lang yung term na inquiry. Tandaan nyo lang ang term na inquiry. Ibig sabihin, it is an inquiry or proceeding to determine there is a sufficient ground whether or not there is a probable cause. Kasi naman, ang hinahanap talaga ng PI class is probable cause. Kaya hindi ka makakuha ng probable cause kung hindi nag-conduct ng PI ang tinatawag natin na public prosecutor or yung prosecutor. Okay? Kasi pag sinabi natin probable cause, ayan sa baba, to engender a well-founded belief that a crime has been committed and the person must be probably guilty thereof. And kailangan natin siya i-held for trial. So ang haba, di ba, ng definition ng probable cause. Tandaan nyo lang, kapag sinabi natin probable cause, yung term na existence of facts. Again, kung sinabi natin probable cause, that is the existence of facts. Ibig sabihin, siya ba talaga yung nakagawa ng krimen or na-involve ba talaga siya sa krimen? So, yan yung tinatawag natin na probable cause. Kasi very important class na magkaroon or ma-find out ng judge na may probable cause. Ibig sabihin, sigurado siya na pwede niya ng kasampahan ng kaso sa korte. Okay? Kasi again, ang PI, it must be executed personally by the prosecutor. Kasi under the old rule cast, pwede pa mag-conduct ng preliminary investigation ng mga judges or yung mga judges in the MDC. Pero ngayon, bawal na yan. Okay? So only the prosecutor, national prosecutor or national state prosecutor, and so on. So yan. Of course, marami akong friends na prosecutors class, lawyers, and of course, alam ko yung ginagawa nila. So, ayan. Okay? Most likely, so in favor yan ng government. So, general rule class, preliminary investigation is required or yung tinatawag natin na PI is a matter of right. Okay? Before filing of complaint. Ibig sabihin, before ka mag-conduct or before ka mag-file ng complaint class, ay i-execute muna or titingnan muna yan ni tinatawag natin na prosecutor kung meron ba talagang probable cause. Okay? Meron ba talagang probable cause sa nangyaring offense or crime. Tandaan niyo class, ang PI is a matter of right kapag yung crime or yung tinatawag natin na penalty or punishment ng crime na nakumit mo is at least 4 to 1. So pag sinabi natin 4 to 1, that is 4 years, 2 months, and 1 day without regard to fine. Ulitin natin. General rule class, ang preliminary investigation talaga, requirement talaga yan class before ka mag-file or before mag-file ang any offended party, peace officer or public officer ng tinatawag natin ng complaint. Okay? So dapat, okay, magkakandak muna ng tinatawag natin na PI or preliminary investigation para makasiguro that what we call yung filing before siya magpa-file ng information sa korte, masiguro rin ni judge na tama yung sequence or tama rin yung procedure nila. Kasi again, pagkamali yung procedure class, automatic it will tantamount to the dismissal of the case. Walang mangyayari automatic i-dismiss yung kaso ninyo. Then of course, ang PI class, it is a statutory right. Binigay yan ng special law natin. Hindi yan binigay ng mama niya or hindi yan binigay ng yung pinaka constitution natin. So again, PI is a statutory right. Okay, it is a personal statutory right. Tandaan niyo, preliminary investigation is a matter of right kapag yung penalty or punishment na nakumit mo is at least 4 to 1. Hindi ka nila basta-basta dalhin sa korte for trial and hearing kapag walang o hindi pa nangyayari yung tinatawag natin na preliminary investigation. Tandaan niyo ang ginagawa ng mga what we call mga judges, ang strategy or a procedure na to, ang tawag nila is what we call the preliminary inquiry. Again, Ang ginagawa ng judge class is the preliminary inquiry. Ang ginagawa naman ng prosecutor, of course, yung tinatawag natin na, of course, ang prosecutor naman, okay. So yan yung PI, okay? Personal statutory right yan, okay? 4 years, 2 months, and 1 day. Okay, ang prosecutor again, PI ang kanyang ine-execute or kanyang tawag nito. Yan yung trabaho niya kasi again ang judge yun yung magde-determine ngayon sa tinatawag natin na probable cause kasi siya yung personally mag-determine yun kung may merong probable cause. Pero class, tandaan niyo sa parlance pa lang or kay prosecutor pa lang class, pwede nang i-dismiss agad ng prosecutor kapag hindi niya nakitaan na may probable cause ang nangyaring krimen or yung na-file na complaint sa kanya. So, meron tayong mga officers class that are authorized to conduct preliminary investigation. Sila rin ito class under the new rule rather. Number 1, provincial or city prosecutors and their assistants. Second naman, we have the national and regional state prosecutors and other officers authorized by law such as the COMELEC, Ombudsman, and the PCGG. So, ano ba yung authority class ng tinatawag natin na Ombudsman? Of course, ang Ombudsman class, di ba, meron tayong tinatawag the Office of the Ombudsman. Ibig sabihin, opisina yan sila class. While the Sandigan Bayan, korte naman yan. Sandigan Bayan Court. Okay? So, ang authority of the Ombudsman class is to extend any illegal act or omission to any public official. Of course, sila yung magkakandak class ng PI or preliminary investigation yung ombudsman natin. Kapag nakitaan ng ombudsman na merong probable cause, ipa-file niya ngayon ang kaso ngayon class sa Sandigan Bayan. Okay? Kasi ang Sandigan Bayan ang magkakandak ng trial and hearing. Kasi nga si Office of the Ombudsman, opisina lang yan siya class. Ang trabaho niya lang is to what we call this, yun yung tinatawag natin na conduct PI or preliminary investigation. Then of course, class, we have the authority of the PCGG. Okay, so we have the authority of the PCGG or yung tinatawag natin na Philippine Commission on Good Governance. Of course, meron silang kapangyarihan to investigate and prosecute yung mga ill-gotten wealth cases of former President Marcos, his relatives, associate, and of course, yung mga graft and corrupt cases that may be assigned or the President to PCGG and to be files with the Sandigan Bayan. Okay? Then of course, we have the authority of the COMELEC to investigate class yung tinatawag natin na election-related cases. Okay? So, yan class. So again, tandaan niyo under the PI, pag sinabi natin PI, it is the inquiry to determine whether or not there is a probable cause. Pag sinabi natin probable cause, that is the existence of facts to engender a well-founded belief that a crime has been committed and the person has been probably guilty thereof. So ang haba-haba ng definition, tandaan niyo pag probable cause, existence of facts. So tandaan niyo, ang probable cause or yung tinatawag natin na PI rather, it is a matter of right kapag yung crime or penalty na nakomit mo is at least 421, 4 years, 2 months, and 1 day without regards to fine. So meaning, ang PI class, it is a matter of right. But of course, ang PI class binigayan ng special law, kaya tawag natin dyan is statutory right. Kasi kapag binigayan ng konstitusyon, ang tawag natin doon is constitutional right. Okay? So again, sino lang yung officers to conduct or authorized to conduct PI class? Una, we have the provincial or city prosecutors and their assistants. Second naman, the national, regional, state prosecutors. Third, other officer authorized by law such as the COMELEC, Ombudsman, and the PCGG. Of course, the authority of the Ombudsman class to conduct pag below 41 po, sir, preliminary inquiry po ba ang tawag? Yes, very good, Bal. Okay, ang tawag natin doon is preliminary inquiry kasi ang magkakandak ng preliminary inquiry class is si judge. Kasi before class, pwede pa si judge magkandak ng PI. Pero gisuspend na yan or binago na yan ng Supreme Court natin. So again, ang tawag natin dyan is yung mga officers authorized to conduct preliminary investigation. Okay? So, Anong oras na? So, pwede na tayo sa... Okay. Okay, class. So, dito muna tayo mag-end sa rule 113. So, bukas mag-start tayo sa arrest ulit. Okay, so mag-start tayo sa arrest para sa ating discussion tomorrow. So, mas maganda yung ano natin, baka matapos na natin tomorrow class ang rule 1 to 1 to 111, 2, 3 and then hanggang sa 1 to 7 class. So, konti na lang matatapos na natin ang criminal procedure. Of course, dapat nandun pa rin kayo bukas kasi yung mga search warrant, warrant of arrest, very important yan hanggang sa search and seizure. Kasi yan yung palaging tinatanong sa board exam. Okay? So, anong oras na pala? So, dito muna tayo mag-end class, then kita kids tomorrow. So, tignan ko kung 6:30 or mas early. So, para ano tayo, maubos natin ang criminal procedure. Okay, isi-send ko lang yung recording natin class sa ating ganon talaga class, pahirap ng pahirap. Okay, so ganon class. So, kapag matapos natin ang criminal law class, madali na yan. Kasi ang mahirap lang naman talaga is criminal law or kailangan ko lang talaga pagtuunan ng pansin yung foundation ninyo sa criminal law. Kasi natapos naman natin ng correction, ang criminology, CDI, forensic, and of course, DEA, madali lang yan, guys. Actually, kayang-kaya i-discuss in just one setting. So, ayan. So, basta tapusin natin by face yung criminal law. So, para matapos natin ang evidence, and of course, matapos rin natin yung court testimony. Okay? So, madali na. Kailangan ulitin sa recorded video. Ulitin yung class yung mga recorded video. So, ayan. So, yung iba kasi akala nila mag-upload ako sa YouTube ulit. Kaya sabi nila, inabagan nila yung recorded video kasi mas naintindihan na nila yung discussion ko. Sabi ko, hindi na ako mag-upload kasi exclusive na yun sa mga student ko. Okay, hindi na nila pwedeng balikan yon. So, kasi ang dami pang gustong mag-enroll sa ating online. But of course, hindi ko na maasikaso class yung pag-entry nila. Okay? So that's why dito lang tayo naka-focus ngayon, class. So ayan. So don't worry kasi ako yung nagka-conduct ng mga lecture in criminal law sa whole Philippines. So don't worry, class, you are in the right what you call this yung right hand, okay? So di ba? So kasi nga ako yung nagka-conduct ng